Adjournment request, if any, from item number 1 to 5. From item number 35 to 48, adjournment request.
May I please, Your Lordship? My Lord, with the consent of the other side, I would like to mention item number 45, my Lord. As there is a bereavement in the family of my senior counsel, kindly adjourn the matter for today, my Lord.
45.
45.
Adjourn.
Obliged.
May it please Your Lordship. Lordship, I beg to mention item number 35 and 36, link matter, Lordship. With the consent of both the parties, Lordship, I pray to Your Lordship to kindly pass over the matter for the day, Lordship.
This Kerala High Court judgment is already there.
Lordship,
Kerala High Court judgment is already there, affirmed by the Supreme Court. Last occasion, we have specifically made it clear that we are not going to apply it.
Lordship, 1 week, Lordship.
No. And the controversy is almost settled. The airport is operating by the private entity since 2021. What remains?
Lordship, actually,
The Kerala High Court has dealt all these matter in details. They have dismissed that.
Lordship, actually, my senior is not well, so kindly, Lordship, 1 week may be given. Like
Not 1 week. The most on 13th,
13th,
yes.
Lordship.
BK Leonard consent hearing for petitioner in PIL petition number
35.
11 of
11 of 9.
11 of 2019. Raised for an adjournment on the ground that the arguing consent is unwell. It is noticed that the issue raised in this PIL petition as well as the connected writ petition is regarding the selection of the contractor for operating the Guwahati, operating the
LGBI airport.
LGBI airport Guwahati. Full stop. The Kerala High Court has dealt with the similar issue in detail and has dismissed the similar challenge made by some of the petitioners. The judgment passed by the Kerala High Court has already been affirmed by the Honorable Supreme Court. Full stop. However, keeping in view of the fact that the arguing counsel is unwell, is this matter on 13th.
Grateful.
These matters on 13th. Yes.
May I raise your Lordship? Lordship, I beg to mention item number 46. Lordship, I submitted an adjournment.
Adjourn.
Obliged, Lordship.
May I please, Your Lordship, I beg for listing of a writ appeal for tomorrow, Your Lordship.
What's the urgency?
The urgency is that I have challenged an advertisement for the post of Chief Administrative Officer. And there was a stay by the Honorable Single Judge not to publish the result. And since my petition, writ petition was dismissed, the results may be out anytime soon, Your Lordship. So there's an urgency, Your Lordship.
Yes. That would be subject to the writ appeal next week.
Next week. The arguing counsel will be is from out of station.
The adjustment since out of council is out of council on the next week. Take it another next week. Don't mind.
Like, can it be day after tomorrow, then 13th? Then Monday, Your Lordship.
Next week.
I'll leave it.
May please a similar matter, my lord, one writ appeal, my lord, against the interim order of writ petition was filed. And the order of interim order of writ, Honorable Singh Judge was stayed, my lord. Now the notice was returnable within 3 weeks, my lord. 3 weeks is about to be completed by today, my lord. So there is a urgency is there. Lifting of PDF articles is there by 17 and 18, my lord.
Next
So,
week. Later.
Day after tomorrow, my lord.
Next week. Yes.
Monday.
I beg to mention a matter, my lord, where I have moved an application for modification of an interim order. This pertains to, my lord, land where the mutation has been stayed effectively from 2003 before the learned single judge and since February 2023 before this honorable court in a writ appeal. I have sought modification. I'm not requesting for any short date. If it can be fixed on a particular date.
Next week.
May I request if subject to
Next
convenience?
week.
May I request for 28th of March subject to convenience? 28th March. Obliged.
Any other request? Daily list for admission, item 1 and 2.
Matter maybe listed for a hearing, matlab, after
Hearing, yeah, they're hearing on admission stage itself.
matlab, this record and those things will be necessary, matlab.
Consider it, yes, Mr. Green.
My lord, what has happened, my lord, in a degree college, a post had been advertised for the,
Facts we are aware.
my lord. Now
Yeah.
my lord, the issue of the certificate is here and whether in a review petition, my lord, the original judgment can be reversed or not.
Why not?
That is the issue, my lord. My lord.
Why not?
My lord, with my very, my lord, what humbly beg to submit, my lord, that the,
In fact,
the
you
fact-
argued the matter.
my lord.
You argued the matter at length.
My lord, as records are, one thing is there, my lord, that the presentation of the, my second certificate, my lord, whether it is before the cutoff date or after the cutoff date, and for that, my lord, the record was necessary, my
This
lord.
is not the only.
My lord,
On 19/10/2023,
my lord.
you argued the matter and it seems court was not convinced, so you took some time to prepare the matter and address the court.
No, my lord, on 19/9, my
Not
lord.
only the certificate, date of issuance of the certificate is immaterial. In fact, you have two certificates
Exactly, my lord. Exactly.
and verifying different communities, OBC.
My lord.
And in one of this advertisement, you applied as a general candidate.
No, no, my lord, in different college, my lord, in
What
different
of
college.
different college, sir?
My lord.
You are you belonging to OBC category. How you can apply as a general candidate, sir?
Because, my lord, that post, I think,
It's as per your convenience.
no, no, my lord.
Where you
They-
want a certificate that I belong to Jola community. Another, you file a certificate that I belong to that Khoti community or whatever the name. And in one of the advertisement, you claim yourself as a general candidate. It's a.
My lord, I will make an attempt to satisfy my lord, my lord.
We are here.
My lord, no, my lord, as the records were called for, I had an
Sir, in
impression.
the record, the learned single judge has dealt with everything in.
No, my lord, the learned single judge originally dismissed the petition, my lord. Then in the review, they have projected a completely new case, my lord. That is our case, that whether, my lord, under the review, my lordship has recently passed an order, my lord.
New facts were encouraged, but
No,
the
my lord, what has
learned single judge
happened?
was satisfied that yes, it touches the very point and therefore it has interfered.
No, my lord, they touches the very point. They have completely projected a new case in the review petition. Not, there is no connection with the
Is there
original
any-
one, my lord.
Is there any dispute about the fact that the director
My lord.
has non-suited you? And thereafter, the principal has written a letter, say he has produced another certificate.
My lord.
That is admittedly after the last date of submission of the advertisement.
No, my
was
lord,
issued.
that is the crux, my lord, that whether I submitted the second certificate before the last day or, my lord, prior to the cutoff date, my lord. So therefore, my lord, the record was necessary, my lord. It is a, my lord may kindly appreciate, my lord. It is a question of my,
Page 14 of the improved judgments.
no, I have, my lord, I have gone through, my lord. That's why, my lord, today I have an impression, my lord, that the record will come. So, my lord can fix a short date, my lord. My lord can fix a short date, my lord. I will make some judgments I am going to rely on, my lord. My lord can be fixed it on next Tuesday, my lord. I will satisfy my lord, my lord.
Though satisfy earlier also you have not been.
No, my lord, earlier extensive hearing was not there, my lord.
Only but the Tulha is not but Muslim, but they cannot be Tulha community.
No, there are.
Yes, but dear, my lord, documents, my lord.
A large scale of population of the, my lord, minority community is Jula. My respected senior friend is not correct, my
No,
lord.
but it is their record, my lord. In Zulha community is this.
The learned single judge has not gone into all this.
Exactly, my lord, exactly.
Learned single judge was simply saying that looking to these inconsistencies, two OBC
Exactly,
certificates,
Miller.
certifying, verifying two different castes.
My lord, my lord,
And in one case you applied as a general candidate,
my lord.
another is West Bengal OBC candidate certificate. How can it be considered valid here in Assam?
My lord, I have found out a judgment of the Honorable Apex Court, my lord, the very nature of the right which I have conferred upon by birth, my lord. That is the OBC, my DNA. That cannot be, my lord, altered or changed, my lord.
Ultimately, the
My lord.
government has to certify that, sir. In many cases, one caste is declared as a OBC,
My lord, my lord.
and another state is not.
That is correct, my lord. No, my lord, if the law is well settled that the caste certificate from the other state, we cannot claim the benefit in our state, my lord. That is there, my lord. I am not disputing on that, but whether,
You
my lord, the
have
honor,
that certificate only.
my lord, the Honorable Apex Court has also held, my lord,
On
that,
the face of it,
My lord.
you still believe a person have two castes.
my lord. No, my lord, because, no, my lord, what has happened, my mother is belong to an OBC caste,
So,
my father is belong to an OBC caste, my
so
lord.
then you'll get 2, 3 certificates of this.
No, no, that's, my lord, that I am not, my lord. I have to rely only one, my lord, with all respect, my lord.
Conduct also,
My lord, I will bring those judgments on record, my lord, kindly, my lord.
judgments. So, I don't think so you'll find any judgment
No,
on this
it
aspect.
is- it
Yes,
is-
despite all these inconsistencies, a person should be granted benefit of the.
No,
reservation.
inconsistency, my lord.
Yeah, learned counsel,
Well.
the appellant, there's some more time to prepare the matter list on Tuesday.
Tuesday, next meeting.
And Mr. Bouquet, record, you please get ready with the record.
Yes, sir.
On Tuesday.
Tuesday,
The 19th morning.
Yes.
Oblige, my lord. Highly oblige.
Item 3 to 34.
My appeal also there.
Both the appeals. Your appeal is nothing. The fresh selection is the only option. Your appeal is nothing.
Lordship, praying for some accommodation in item number 3 to 14. Lordship, Dr. Sharaf is in item port number 2, Lordship, of the matter. So after some time,
Take, think so it will not be going to, arguments are not going to complete in one day.
Lordship,
4-5 days will be required at least.
It is required. What about the state, other states?
Lordship, here I am appearing for the state of Assam. Lordship, otherwise we are ready, Mr. Saikai is before the special bench in court number 5. Today there is, he will be joining if Lordship, sir.
We'll put the date. We will let you know.
Lordship.
Much obliged. Mr. Bishop.
Item 37.
Okay. Ask me about the time.
Item 38 to 40.
My lord, these writ petitions are referred by Honorable Single Judge. I am appearing for the respondents. The order of reference is dated 22/2/2020, 22,
22 to
2022.
the London single judge has referred it to the.
Yes, my lord. There is an earlier judgment, my lord, which we tried to distinguish, my lord, and Honorable Single Judge, my lord, referring with their judgment, deemed it appropriate to refer it to the division bench. The case leading this batch will be, my lord, 3433 of 2020, my lord. That's Kunal Kashyap Patodia. We have a computer project of the Service to. Main help. Right.
ইয়াতে মেম্বাৰটো ক'লে ইয়াত কোৱা নাই মানে কি কিন্তু ইয়াত লাভ নাই এইটো কেছ কৰি তিনিটা কেছত টেঙা হাল তোমাৰ এই ৰুল চেলেঞ্জ কৰা আর কে গুপ্তা রাজি মানে তার মাথা খেলায় আছে রেটটো বেশি তুমি যদি এতিয়া নকৰে নহয় মোৰ মতে ৰমনক লগাই দিওঁ নেকি নাকি মানে কি হৈ যাব ইয়াতে এডজাষ্ট কৰা মন নহয় এতিয়া নকৰি কি নাপায় আকৌ আহি যাব কি যাবি বেলেগ এটা মিলা কোনো চাকৰি কৰি ইয়াত নাই বেলেগ এটা নিলে নহয় পাকচি বুলি কাম চিটি হয়
Yes.
My lord has read the referral law. My lord, in my humble submission, I think that the reading of up to 4 and 5 will cleanse the issue. Please have a good. Now, if we are to go by what the referral judge has said, my lord, then we'll be reading something into the rules which rule-making authority never intended to include it. That means that this degree must be acquired while in service. Only then a meaning can be given.
At the time
But that
of
is not
entry-
there.
At the time of entry,
Ah,
the degree is not.
there is no such prescription.
Should not be there, and after
Yes.
entering into the service, he should have
Now,
acquired.
please come to sub-rule 4 of 11, rule 11, my lord. Huh? Irrigation. বেছিৰ ওচৰত মোক কপি এটা দিবা নেকি? হা? এইখনে? অ।
Public health engineering.
Yes, এইখন?
Here we are concerned for that public health engineering.
Irrigation department. Irrigation is two different, public health engineering and irrigation.
Irrigation to লৈছো এইখন?
First case is the public health.
Of first case is of public health, PhD.
But cases of irrigation নাকি?
Irrigation to item 39 illicit irrigation. 38 illicit.
Okay. Then my lord will kindly come to rule 11, my lord.
11 of
Sub-rule
PhD
4.
rules. PhD rules.
Yes.
Yes.
Sub-rule 4.
Appointing official.
Yes.
Official gazette.
A member of Assam Subordinate Engineering Service shall be eligible for promotion as assistant engineer, subject to the following conditions, namely, he has minimum qualification of diploma in engineering or equivalent as recognized by Government of India and has rendered minimum 8 years of service as junior engineer on the 1st January of the year of promotion. So my lord, here the specific word used is a member of the service. That is Assam Subordinate Service. But now if your lordship kindly comes to rule 5, first of all, my lord, it starts with a non-obstante clause. And the due meaning has to be given to a non-obstante clause apart from anything else. Now kindly see, notwithstanding anything contained herein before in this rule, on suitability, a junior engineer of Assam Subordinate Engineering Service, on his acquiring the academic qualification as prescribed for direct recruitment, the direct recruit engineer shall be promoted as engineer in consultation with the commission as provided in Rule 14 against the next available vacancy in the cadre, and such promotion shall be treated as direct recruitment to the cadre of assistant engineer for the purpose of this rule. Now, my lord, the referral judge, in my humble understanding, my lord, having regard to the word acquiring, was of the view that it is only those subordinate engineers who, while serving as subordinate engineer, acquires the degree, then he is entitled to the benefit under sub-rule 15. But most importantly, my lord, the legislature or the rulemaking authority, unlike in Rule 4, where it says a member of the service, here, my lord, it is not said. The rule is silent on that. Not to speak of.
No, they said, no, sir. Junior engineer of Assam Subordinate Engineering Service, PhD. Member of service.
Member, sir, but my lord, that he has to acquire this degree while in service, that is not there. Unless that is there, how do we support the view of the?
On his acquiring.
Yes, my lord. Now, my lord, this word acquiring can be also understood as acquired. Because why I'm saying so, my lord?
What we
Now, my lord, I'll give an example.
Suppose if the intention of the legislature was that a person who is already having the degree is also entitled for that, they would have used the word a member of the judicial service on acquiring the karke having graduation degree or whatever it may be.
No, my lord. Question is, with a higher degree, if a person enters a service which is not, which is more than what is the degree required for that particular job, can we read a limitation into it? We have to look it from the,
What the learned single judge intention
no,
was
what
that-
the learned single judge says,
his intention was that since they, despite having this graduation degree,
yes,
not applying to the post of the assistant, they chose to apply for the junior engineer where the diploma is the this
yes,
minimum qualification or
yes.
required qualification.
Ah.
And therefore, they were aware that they are going to now, the promotion will be given to them while considering their degree or their appointment as a junior engineer, and they are not entitled for
But my lord, even if they get this promotion, they will be still junior to those that are direct recruits who is already in the service. That is an aspect which learned single judge has wrongly, erroneously decided. My lord, by becoming a junior assistant engineer, I don't stand to gain anything qua the persons who are already in the cadre.
already.
And you see, my lord, even if I get this promotion, it will be treated as a direct recruitment. Now that I cannot bypass the direct recruit who are already in the service of assistant engineer.
This direct recruitment, learned single judge has raised a concern thus by this method.
Ah,
The petitioner wants to steal a mark over the junior engineer who otherwise would become eligible for promotion on the next higher post of the SC after rendering service of 8 years. This, in the considered opinion, would amount to giving unfair advantage to the petitioners who have option being selected and appointed as SCJ on the strength of the existing graduation degree.
Hmm.
This is what in para number 20.
yes, I'm reading, my lord. In this case in hand, the petitioners having higher qualification of graduation degree in civil engineering, though eligible to apply for direct recruitment the post of engineer, assistant engineer, with eyes open elected to be appointed as junior engineer, which requires lesser qualification of diploma in civil engineering. Case of the petitioners number 7, 20 and 32 is no different because they knew that they were in the verge of obtaining their
Sir,
respective
which para you are reading?
para 20, my lord, of the referral order.
Referral order, sir, para.
My lord, I was reading, my lord, 2843 of 2020.
Here,
I'm actually, I mean, it took I think Lordship is taking another brief. I'm holding, I'm reading item number 30, na?
39.
39.
we are having this, not 39, 38. Here,
Hmm? Para 20, my lord.
just a minute. The order is of same date.
My lord, para 20, this starts with in this case in hand.
Yes, yes.
Oh, माहिती घेतो का एक ना? तुम्हाला करतो. Referral order. Same date, my lord, 22 to 22.
Yeah.
Yes. In the case in hand, the petitioners having higher qualification of graduate degree in civil engineering, though eligible to apply for direct recruitment to the post of assistant engineer with eyes open, elected to be appointed as junior engineer, which require lesser qualification of diploma in civil engineering. The case of petitioners number 7, 20 and 32 is no different because they knew that they were in the verge of obtaining their respective graduate degree in short time, but with wide eyes, they opted to compete with diploma holders to be appointed as junior engineer with lesser qualification. Yet after joining the services, a service is seeking fast track promotion to the next higher post of assistant engineer with a pre-existing graduate degree. Thus, by this method, petitioners want to steal a march over other junior engineers who would otherwise become eligible for promotion to the next higher post of assistant engineer after rendering 8 years of service. This, in the considered opinion of the court, would amount to giving unfair advantage to the petitioners who had not exercised option for being selected and appointed as assistant engineer on the strength of the pre-existing graduate degree. My lord, my humble submission is, my lord, first of all, sub-rule 5 start with a non-obstante clause. The intention of the rulemaking authority is to give overriding effect to sub-rule 5. Having regard from that perspective, my humble submission is, my lord, this observation of the referral judge may not be correct. Because when you are expecting some benefit in terms of a non-obstante clause, you cannot make comparative assessment qua another provision, which provision is sought to be overridden by the non-obstante clause, notwithstanding anything contained. So this comparison, my lord, in my humble submission is not correct. Because in spite of there being a provision in Rule 4, whatever may be the sub-rule 4, whatever may be the provision, sub-rule 5 intended to carve out a class giving a preference. Now, my humble submission would be, my lord, lordship will judge the implication of sub-rule 5 independently, without making any correlation with sub-rule 4. Now, entire emphasis of the learned single judge is, by virtue of Rule 4, the route is longer. Now we are adopting a fast-track provision. So that is where, my lord, this glitch has arisen. Therefore, my humble submission is, my lord, the sub-rule 4 and 5 has to be read harmoniously. So reading, my lord, and having regard to the purposive interpretation, what follows in my humble submission is, sub-rule 5 carves out an exception, and that has to be given effect. तुम बता दियो it is grammatical interpretation to get avoid but no, based on statute. Lord, I'm relying on a passage from Crayon statute law as to when grammatical interpretation should be avoided. Now, if a lordship would kindly come to page 85, my lord, under the heading Golden Rule of Construction, please come to page 85. The subpara. The onus is on us, but we can always make this submission, my lord. In Richards versus McBride, Groves said, I even doubt whether if there were words in the act tending strongly the other way, I could pass from the plain grammatical construction of the phrase in question. The onus of showing that the words do not mean what they say lies heavily on the party who alleges it. He must, as Park be said in Beck versus Smith, advances something which clearly shows that grammatical construction would be repugnant to the intention of the act or lead to some manifest absurdity. And in Duke versus so-and-so, Linley put the rule thus: you are not so to construe the act of the parliament to reduce it to rank absurdity. You are not to attribute a general language used by the legislature in this case, any more than in any other case, a meaning which should not carry out its object, but produce consequences which to the ordinary intelligence are absurd. You must give it to such a meaning as will carry out its object. It is always proper to construe an ambiguous word or phrase in the light of the mischief which provision is obviously designed to prevent, and in the light of the reasonableness of the consequences which follow from giving a particular construction. My lord, the basic purpose of sub-rule 5 is to give an advantage to a graduate who is in the subordinate service over a subordinate engineer who do not have a degree. Now, therefore, to confine the meaning on acquiring, in my humble submission, my lord, would defeat the object of the very insertion of the provision. Therefore, merely because with a graduate degree I joined the service, therefore now I cannot claim that cannot be the my lord intention. Thereby we will be restricting the scope of the legislation, my lord. I won't say that it's an absurdity, but certainly, my lord, will be reading something which is not there in the rules. So basically, my lord, I think, and that view has been taken by another single bench of this court, my lord. Now let us see what is the wrong in the other view. Yes. My lord, if a lordship should kind, I'm sorry, my lord.
This sub-rule 5,
Yes.
in a sense, to some extent, the learned single judge was right in saying that it simply says acquiring and not acquired, and therefore some doubt is there. And why don't you challenge this rule, validity of this rule? It gives a unreasonable, that they are acquiring and acquired persons,
my lord.
they are giving something. Why don't you challenge
My
the
lord,
validity of
before,
this rule itself?
oh man, I'm so sorry.
It's better to challenge the validity of this rule itself.
No, my lord, let us, I'll answer to that, my lord. If your lordship should kindly come to page 54, the view of the other judge. There's another view, my lord.
That is this.
Yes.
This is the learned single judge.
Yes. My lord, the judgment starts at page 50. And I'll have your lordship's kind attention to page number 54. Para 8 onwards.
Yes.
To explain the several instances in the past of such promotion being granted in the department to junior engineers who joined as junior engineers with additional academic qualification of graduate engineers, the departmental council contended this practice in the department was discontinued after department decided to stop referring promotional matters of junior engineers to a PSC. The above explanation given by the departmental council to justify a departure from the earlier practice of considering cases for promotion of those junior engineers who had already acquired this graduate engineering academic qualification prior to joining service as junior engineer is difficult to accept as a reasonable classification. No change in Rule 11(4)(c) was incorporated because of abandoning the practice of consulting APSC by department for making promotion to the cadre of assistant engineer. And under such circumstance, the claim of the petitioners for getting promotion to cadre of assistant engineer because of the graduate engineering academic qualification possessed by them has to be judged on the basis of provisions of Rule 11(4)(c) of the rules. My lord, 11(4)(c) of the PWD rule is, my lord, perimetry at the sub-rule 5. Rule 11(4)(c) obviously provides for a faster mode of entry into higher cadre of assistant engineer for those serving as junior engineer. The rule does not rule out consideration of cases of those who have already acquired the higher qualification prior to their entry into service in the feather cadre of the junior engineer. From the several instances of such fast-track promotion given, it is apparent that the department had all along been considering the promotion for junior engineers who possess or acquire the graduate engineer qualification without making any distinction amongst them who acquired the qualification before or after entering into service.
Here their case is this, we are not, we have never granted any
No,
promotion.
my lord, no, then it is not only from that perspective that the other honorable judge took that view, my lord. There are independent reasoning also. Yes. The department tries to justify the abandoning of the above practice because of replacing the practice of consulting APSC by consulting the DPC for making promotion to the cadre of assistant engineer. This explanation furnished by the department cannot, in my view, is acceptable as no corresponding change in the rule has been incorporated to do away with the long-standing practice followed by the department. There is really no basis to make a distinction between those who acquired a higher qualification after they joined the service and those who joined service in the lower cadre with additional higher academic qualification. Therefore, non-consideration of the cases of the petitioners for promotion under 11(4)(c) of the cadre of assistant engineer is found to be discriminatory, and the same therefore violates the petitioner's right guaranteed under Article 14 and 14(c) of the Constitution of India. Insofar as advertisement dated so-and-so whereby 78 assistant engineers has been advertised for filling up the post through direct recruitment, it is submitted by departmental council that the said direct recruitment exercise to 78 posts would not include the 30% of total cadre strength of the assistant engineer earmarked to be filled up by promotion of junior engineer. From the above submission, I can understand that 30% quota meant to be filled up by promotion in the cadre of assistant engineer are available to filled up by eligible serving junior engineers. The petitioners herein are contender for promotion on the basis of higher academic qualification under provisions of Rule 11(4)(c) and not under provisions of Rule 11(4)(a). And since such promotions are to be considered subject to availability of vacancy in the cadre, I am of the opinion that direction should be issued to consider the cases of the three petitioners for promotion to the post of assistant engineer under provisions of Rule so-and-so. If vacancies in the promotional quota is available, it is ordered accordingly. Lord, the learned single judge in para 12 was clearly of the view that the rule does not make any distinction between those who had acquired the degree before joining or those who had acquired the degree post joining. At least, my lord, that is not as discernible from the reading.
Rule 4(c), this.
Is akin to rule sub-rule 5, my lord.
Just a minute.
Yes, yes. If your lordship is holding this book, my lord,
Yes.
assess,
Yes, it is.
assess.
पेज तो नहीं मिले डॉक्टर पेज नंबर 27 वाला हम पेज
PWD এখন to
और पेज लिखन दिखाओ
PWD বিচাৰিছে এখন to PWD আছিল
और ये देखिए तो
no court was considering PWD. If your lordship should kindly come to 11(3), my lord. This is here what we have sub-rule 4. Earlier it was sub-rule 3. 4. A member of Assam subordinate engineering PWD service shall be eligible for promotion as assistant engineer subject to the following conditions. I think page 8, my lord.
पेज तो
Oh, page, acha, subsequent, maybe subsequent edition. PWD rules, my lord, 11 sub rule 4 is the normal promotion and 4C is the perimeter provision like sub rule 5. Okay, too. Oh no, it is C. C, yeah. Notwithstanding anything contained herein before in this rule, subject to suitability, a subordinate engineer grade 1 of Assam Subordinate Engineering PWD service on his acquiring the academic qualification as prescribed for a direct recruitment assistant engineer shall be promoted as assistant engineer in consultation with the commission as provided in Rule 14 against the next available vacancy in the cadre, and such promotion shall be treated as direct recruitment. Therefore, my lord, in my humble understanding, subject to what your lordships may say, my lord, if we give a grammatical meaning to the expression acquiring, in that case, my lord, the very purport of this fast track promotion will be defeated. Therefore, lordships will not adopt that. Because there is nothing in sub rule 5 to take a view that this degree has to be acquired while in service, or that a person who is already having a degree will not be entitled to the benefit of sub rule 5. End of the matter, my lord, only a person with graduation, he can be eligible for either direct recruitment or promotion to the grade of assistant engineer. And there is no dispute that we are having the degree. Now the question is,
only question is the word acquired means after entry into the service
or
prior to that?
whether it will also include persons who are already having for this thing. Or my lord, in that case, legislature could, the rule-making authority could have used the expression that that after, the word after should have been there, my lord, was acquired after entering the service.
Should have
So
clarified.
therefore, my lord, this golden rule of construction has to be avoided.
Another argument is, they could have used it that already possessing the requisite.
Therefore, whether we should adopt grammatical interpretation. Of course, since I am making an argument to the contrary, the onus is on me, as Craig says so, Miller. Craig on statute law says, those who bring out the point, the burden is upon him. And I am trying to discharge my burden by saying that to become an assistant engineer, all that you need is a degree, which I have. Now, sub rule 5 gives provides a fast track provision. What is the requirement? You must be a degree holder,
Degree.
irrespective of the fact whether you
Whether it
obtain
is
prior or
acquired
after.
After entry into
Yes.
service or prior to that.
So that is my line of understanding, my lord.
And,
Subject to
armed with this judgment of the learned single judge also.
yes. Or if your lordship wants, I can further. Manoj, it's a very interesting thing. All depending upon your. You can also.
Depends upon what, if you feel that something more is required.
My lord, silent, yeah, no? Yeah, no? তার পিছনে আপনার বলবো নাকি? আমি এক্সটেরিয়র লাগালো 18 তারিখ মানে হ্যাঁ 18 18 ফুল তো 18 আৰু 20 বিলাক ফুল তাতে তো। সাতাইশ ফুল হ্যাঁ পঁচিছ ও লংচি আছে
Yes, sir.
My lord, if it is not, could it be on 27, my lord? Or lordships would like to continue with the combination?
27.
Yes. My lord, maybe I'll find something more also, my lord. Every day, we do not often come across such cases, my lord.
Mr. Goswami, also come where
Yes, I'm prepared.
27.
Oh, photocopy, yes.
27.
Item 41 and 42.
May I please the lordship?
Lord, connection rate appears preferred of a mellow. Connection in connection with the same single judgment mellow.
Yeah.
That is not on board today. It has only the serial number mellow today. So can it be taken up that rate appeal?
Writ appeal number?
It is serial number 3055 of 2025.
List along with, more weeks.
Item 43.
We were required to file an affidavit on the availability of. On 25th, we filed that affidavit, whose records are not available. What is the note?
Available. Existence of the record was denied or not?
It was denied.
Denied.
It was denied. Second aspect, my lord, of this matter, of course, 97, whether they were entitled to not is a different issue. The second aspect, my lord, with the evolving jurisprudence now, my lord, is that these people still continuing, my lord. Still continuing. And the recent trend I find that, my lord, the court is taking a view that even though Umar Devi was there, just continued engagement for 20, 25 years, they deserve a separate concept. I have done is that I have asked the corporate office to take all on that. Either your lordship decides or
I do.
maybe we, my lord, if lordship gives me a and they sign.
It is open for you. Because whatever it may be in the 97, maybe the claim was not there. But if they are working from last 30 years or around 30 years, now they need some, some separate consideration is required.
Look, some of them are,
Apart from all this, in the 97 or for that, they have not produced any evidence or whatever it may be. But the fact remains that still they are continuing.
My lord, definitely, I'm trying to, my lord, sort it out.
look, so
रिटायर हो गया
সুপ্রিম কোর্ট বসে যায়। পেনশন না পাবো না, এপ্রিলের তো কাম নহলে।
What is the judgment of the tribunal?
My lord, I have judgment of tribunal. Yes. Lordship will find page 365 and relevant portion, your lordship will find 412.
360.
It starts from 365 and relevant portion 412, my lord, wherein the discussion with regard to the present petitioners.
Group of petitions were decided, my lord.
Oh, we understand.
412 is with regard to the present petitioner.
Present petition.
Yes, my lord.
That TA number 69.
No, it is actually 62/09, but it has wrongly written as 59, my lord.
Okay.
This case can be continued. Others have all been disengaged in 90 days.
These persons are only continuing.
These are.
No, another difference is already there because there is a finding by the tribunal itself that 240 days we have completed. Although they are denying it, but there is a finding by the tribunal from the document.
The petitioners
My lord, one,
herein.
I'm sorry, yes,
Take order, then you.
my apologies.
The petitioners herein has approached the central administrative tribunal. What event? Herein after to be reported. And with the prayer that the respondents be directed to regularize their services under the casual laborer in bracket grant of temporary status and regulations bracket close schemes 1989 on the ground that they have already completed the required 240 days in the employment of the respondent BSNL. Full stop. In support of their claim, the petitioners has relied upon certain documents such as certificate showing such a certificate showing their continuous engagement with the BSNL, finding of verification committees, etc. Stop. The respondent BSNL took a stand that since the originals of the said documents are not produced and the same are only photocopies which are not authenticated, the petitioners are not entitled to get any relief on the basis of the said documents. The tribunal has rejected the claim of the petitioners for regularization only on the ground that since the documentary evidence produced by the petitioners in support of their claim of regularization are not authenticated and are not original one, no relief can be granted to them. Full stop. In the before this court, the petitioners are claiming that the they have discharged their primary burden by producing the relevant photocopies of the relevant documents, and now it is for the department. Now it is for the employer BSNL to come out with a clear case that no such documents were at all in existence. It is contended that the respondent BSNL has now has simply stated that the originals are not available with them, but they have not disputed the effect of existence of these documents at any point of time. Stop. Be that as it may, it is to be noticed that the petitioners were engaged by the BSNL years before, and till date they are continuing with the BSNL as casual laborers. As casual laborers. Full stop. Recently, the Honorable Supreme Court in Jagu versus Union of India and Anita and others versus Union of India reported in 2024 SCC online 3826 has opined that the when the casual laborers are working for years together. Their cases for regularization, their cases for regularization are to be considered irrespective of the riders provided in the Uma Devi. So and so that sutra is stated in Uma Devi's case. So, learned counsel for the BSNL has frankly submitted that there is no dispute about the fact that these petitioners are still continuing as laborers, as casual laborers with the BSNL, and their cases are required to be considered as per the latest judgments passed by the Honorable Supreme Court. Stop. Mr. Patel, therefore, seeks 10 days time to complete his instructions. Just after 10 days.
Item 44.
Much obliged.
Who is appealing for the petitioner?
He is from ideological.
Were any information that whether he's coming or not? What's the matter about?
Lordship, his petition was dismissed, Lordship, regarding correction of date of birth, Lordship. Premature, as per his contention that he was retired premature. Lordship, it's another date.
In this matter, the learned single judge has also sought some information regarding the date of birth of that brother and all.
Yes, yes, yes.
None present on behalf of the appellant. With this speak with date, there is no fiction. Approve any date on hearing day, unless this not.
29th April. Item 47.
If I beg to appeal 46, Your Lordship. 46 was,
Some adjournment slip was already there, so we have adjourned it.
my consent was not taken, Lord. I've come from outstation,
I
Miller.
don't know.
And on the
But
last
it was
occasion,
circulated in advance and who made a prayer for that?
in fact, my early hearing was allowed and the matter was kept in the first week of March, Lord.
Yeah, sorry, we are not aware who the person was. In fact, the adjournment slip was already there. Adjournment slip. Sorry, sir.
There's no stay, and Millard, he's got 3 promotions. The
Yeah,
respond
listen,
number one.
but we have not applied a mind since.
I
adjournment slip
understand,
was
I
already
understand,
there.
Millard.
So don't think so there was any objection on that or something.
Millard, may I request a specific date, Millard?
Yeah,
Please?
we-
I'll take a date. Obliged.
Sorry. Sir. Yes, ma'am.
Your Lordship, I'm appearing for the respondents. Last time also we had argued the matter and tendered a compilation.
Yes, yes.
I'm appearing on behalf of the
You are appealing for
respondent.
respondent. Who is appealing for this revenue? Mr. KL.
Yes, also.
Last time also it was Mr. No. Mr. KL. Okay. Also for the timing. Let's wait for it.
Item 48.
My pleasure, Lordship. At this stage, my matter is very urgent. Now, petitioner appointed as a statistical officer on the recommendation of the Assam Public Service Commission in the year 1992, and he was promoted to the post of a research officer. Promoted to the research officer, then he promoted to deputy director economic statistics. At the basic entry at the qualification, statistics, mathematics, economics, commerce. As Ira would have been, in the year 1995, the said service rules, it has vested interest of some person. Commerce subject is deleted. Commerce subject is deleted. Then I am going to the victimized. I am the senior person. Now, what happened? I am filing the affidavit in the last week, acting as a in charge of the director and additional director. My service is only 1 year. I am going to be the victimized. As a result, the registrar deprived from the eligibility claim for the director of economic and statistics under the Transformation and Development Department. In this case, Your Lordship, affidavit extends by the respondents.
This advertisement is under challenge. The advertisement is under challenge.
The advertisement challenge, Your Lordship challenge.
Where is that advertisement?
Yes, 50.
Page
50.
50.
50. Yes. They filed a affidavit in opposition.
This tenure of this the post which is in advertised is
Director of Economics and Statistics.
tenure 1 year.
Oh, 1 year.
So that 1 year is already over.
No. I am after only 1 year service now.
Yeah.
Now, I am holding the in charge of the director. They again advertise this post.
For which you have filed a contempt petition.
During the
Now, for all practical purposes, this advertisement is now over.
That advertiser was again advertiser. Now, Your Lordship.
Advertisement which was
No.
in the petition. My lord, pertain to that advertisement selection was held, and thereafter the person selected
The term was also expired.
He is also retired from the service. The person who was selected and appointed also retired from service. Now, my lord, the press advertisement is for the popular of the.
In which the selection has already taken place.
No, my lord, that.
The fresh advertisement also issued or appointed person was appointed as director.
By the.
Now, however, I have already filed a decision in this connection.
But that advertisement is not under current.
I filed a decisional affidavit.
My lord, what was the rule under current? Your lordship may kindly see, para 13, page 13, no. Very petition.
During the pendency, there is an interim order also.
The page, it was subject to outcome of the
Page 13,
page 13, my lord, paragraph 12.
1-3, yeah.
Yes. The original, my lord, rules was the qualification A, at least second class master degree in statistics, mathematics, economics, or commerce from the recognized university or its equivalent. My lord, the statistics, mathematics, and economics are the subject. And commerce is this, my lord, field. And statistics, mathematics, and economics is the common subject of art, science, and commerce. That is why when there was a mistake of my lord incorporating the word commerce was deleted in the year 1995 by way of amendment of the rules. My lord.
1995.
95. And since 1995, pertain to the.
Where is that amendment? Where is that amendment?
My lord, page 14 and page, my lord, page 15 is the, my lord, amended.
This commerce effort shall be deleted. At least second class master degree.
Incorporate provision is, my lord, after amendment. At least second class master degree in economics, statistics, or mathematics of a recognized university or institute.
Yes.
And that has been corrected in the year 1995. Petitioner challenges the advertisement, which was, my lord, published in the year 2023, was challenged. And learned Singleton said, my lord, since this was not, my lord, rules was not challenged. My lord, he dismissed the honorable Singleton dismissed the petition. And then, my lord, his petition preferred challenging this crime.
I like to submit your lordship, during the pendency of this writ petition, and honorable this court has passed order
Subject to the. Subject to.
subject to the outcome of this petition, and another suggestion is there regarding the relaxation order dated. Order dated. Your lordship may kindly be record will speak the truth. On 23/11/2023.
Yes.
There is a provision of the service rule, the relaxation. That relaxation was not given an opportunity also. Long order. I am the learned counsel for the petition of the MP Sharma, additional advocate, some for the respondent, 1, 2, 3, 4, 5. And so all the TM on the learned counsel for the MP Sharma, learned counsel for the respondent number 4, Assam Public Service Commission. The respondent APSC by the advertisement number 22 to 23 and dated to 24 is advertised for the post of the Director of the Economics and Transformation and Development Department of the state. That was published in the newspaper on 25/8/2023. prescribing amongst other the following qualification, including the educational qualification as and as that are the educational qualification. Second class master degree in statistics, mathematics, economics, and from the recognized university. Degree of a recognized university, mathematics, statistics, economics, or statistics subject to the diploma recognized by government obtained at least 2 years post-graduate training in the statistics. Note, director of the research degree in statistics, mathematics, economics, statistics, not less than 10 years experience in statistical work, investigation, research in government development, commercial concern of this food. In conducting the guideline the research in the statistics in the university institute training research as evidenced by the published work, administrative experience for not less than 5 years in a responsible capacity is the candidate should not be less than 35 years of the age and not further than 45 years. Is on 01/0/23 provided that the candidate belonging to the Assam Economics and Statistics Service shall be no upper age limit. The age limit of the candidate will be calculated on the basis of the matriculation SLC admit card pass certificate issued by the recognized central state government board council where age date of birth is clearly reflected. No other recruitment shall be accepted in lieu of the mentioned documents for age 2. 3. As per the state advertisement number 2481, the day is starting the date of online application was 01/01/2023. The closing date of the
So what happened to your advertisement, this representation?
Representation as per honorable court order. I am communicated the learned advocate of the government. The learned advocate already filed affidavit and they are praying for inclusion of the commerce subject.
They?
The government is the director of economic and statistics filed affidavit for the inclusion of the commerce subject.
For inclusion of the commerce subject. Where is that? Who
The file affidavit.
Huh?
File affidavit. The affidavit in opposition clearly stated that during the pendency case.
Where is that affidavit in opposition? Which page?
Your lordship. Director of economics. Is 97 degree. 97.
Yes.
Is 97.
Yes. '97.
It is 97. Para 6 or 6 and 8.
3.
6 and 8.
6 and 8.
6 and 8.
This is the judgment passed by the learned single judge.
No, division bench, sir.
Huh?
At the stage of the division bench, they filed affidavit.
Where is that affidavit, sir? Page 97 is the order passed by the learned single judge.
No. During the pendency of this the petition.
Sir,
Yeah.
here in this appeal, page 97 is the order of the learned single judge.
The director. Page 54.
Which paragraph in the affidavit you want to rely?
No, your lordship, another, the page 54. The additional director wrote a letter, director to the additional director. Additional chief secretary. Additional chief secretary to the government of Assam. Page 54. Page 54.
So he has proposed this amendment should be made. This is what you want to say.
Inclusion of the commerce surplus is required. Your lordship, my respectful submission, rule is ultra virus.
How? Why?
The rule is ultra virus.
Is it
There
without
is a,
competence? Is it without competence? The government has no competence to.
no,
make
your,
such rule?
I like to respectfully submit. In Mizoram government also commerce subject. In Andhra Pradesh also commerce subject. whatever it may be, your lordship may kindly peruse my case law, first case law,
Direct case law, okay.
first case law.
What happened to his representation for relaxation?
My lord, that has not been considered because, my lord, the persons, the commerce graduate person who hold the post of director, they have repeatedly, my lord, preferred the representation before the government. And now also, my lord, the client of my learned friend, the petitioner is holding the post of the director on in-charge basis. After, on in-charge basis.
Now in service.
After retirement of the person whose, my lord, election was settled. He retired, my fresh advertisement has already been issued, and he's holding the post. And that type of directors who hold the, my lord, who was a commerce graduate, without the subject of statistics, economics, and, my lord, mathematics, repeatedly filed the representations, my lord. There are several representations filed by, my lord, vested interested group.
Yes.
It's a similar situated case law.
The post of, my lord, director of economics and statistics cannot be filled up without the concerned subject, my lord. That is the problem. If, my lord, the commerce case earlier rules is allowed to prevail, my lord, then the commerce case without having the statistics, economics, and mathematics.
Was getting the
would be
promotion
allowed
to the
to-
even after
Now he getting the promotion. Now he is a post of additional director. Then inside of the director.
Case laws, case law.
No, like affidavit, your lordship may kindly peruse my affidavit. Or similar situated case, your lordship,
Where is that? Which is
similar
that case?
situated case, serial number 1, I am already submitted.
Okay.
I rely on the plan number 2, 3, 5, 10, to 12, 14, 15, 16, 17, 19 to 20, 21. Okay. This honorable court has passed the similar
So
situation.
please read the judgment with the paras on which you are relying.
Para number 2. The 4 read petitioner who are serving the inspector of the arm under the Mizoram police have approached the court by filing the instant read petition challenging the proviso rule 561 of the Mizoram Police Service Rules 2008 and on the ground that the same is otherwise the Constitution. 3. The condition of service of the inspector of the service under the Mizoram Police used to be governed by the provision of the Mizoram Police Service Rule 1997. The hearing after refer as to the rule of 1997 framed under the proviso to Article 309 of the Constitution. I mean the Rule 6 of the Rule 1997 laid down a procedure for filling up the substantive vacancies in the junior grade of Mizoram Police Service, Rule 6 of the Rules of 1999. He is produced herein below for ready reference. Recruitment to the service of the commencement of the 3 rules shall be by the following the methods only, namely 50% the substantive vacancies to the junior grade of the service the who is occur from time to time shall be filled up by the selection from the amongst the officers who have served in the cadre of the inspector of police under the government of Mizoram not less than 5 years.
Sir,
in the
which
grade.
para, relevant para you are referring?
Yes, relevant.
Relevant para.
Relevant. I am reading the relevant.
Which relevant para you are reading?
Para number 3.
Para number 3.
3.
These are the facts. This is the law laid down.
Para number 50. With para number 15. But furthermore, for the meticulous examination of the rules, 6 of the rules of the 2008, we are also of the opinion that the provision to the rules have been added so as to introduce a distinction between two categories of inspector, one belonging to the armed branch and other to the unarmed branch. Even though the principal provision of the rule 6 of the law does not admit of any such distinction between the two categories of the inspector. Therefore, we find force in the submission of the K.N. Chaudhary, Standing Counsel for the appearing for the prisoner, that the provision CC to the unconstitutional limit the promotional avenue this crime, thus extending the unfair and discriminatory treatment to them. 16. It is no doubt correct and that the ordinarily the court would presume constitutionally of the any legislation unless the
Yes, yes, sir. We have gone through your this and you're relying on these paras. We'll take into consideration these paras, which you have referred in this gist. This para number 2, 3, 5, 10, 11, so and so, and thereafter in another, this Punjab State Cooperative, we are relying on 47, 52, 58, and other. We'll look into it. We'll look.
Another decision.
These decisions will look into it. All the decisions which you have referred around this 7 decisions, 8 decision will take into consideration all these decisions.
Yes.
Yes, Mr.
My lord, my humble submission, my lord, first of all, my lord, amendment of 1995 is challenged, my lord, after a long period, my lord, on the basis of which, my lord, earlier so many elections were held. And secondly, because the post of, my lord, statistics and economics cannot be filled up without having the required, my lord. And if, my lord, the or commerce, that was, my lord, economics, statistics, mathematics, or commerce. If the commerce word was not related, then, my lord, commerce graduate without having the required subject be allowed to, my lord, hold the post of director of statistics and commerce. That cannot be, my lord. There was a mistake that was in
Counter affidavit is there?
Yes.
No, my lord, I like to submit one thing. That is not a effect. The commerce subject, man of the commerce subject also holding the director in previous occasion also. That is unconstitutional matter.
We'll consider.
The other decision.
In that case, my lord, since the amendment 1995, no, my lord, person without having the requisite qualification.
Prior to that, you have.
No, already your I I like to submit one thing. Why the department recommended to include the commerce? That are affidavit in opposition.
That is director has this director has written recommended for it.
Or recommended. Recommended. But your lordship, he service only 1 year now in charge of the director. And he holding the additional director post. It is going to be deprived.
Don't this.
He is getting promotion.
What is the order is the Mr. Kayal, what about this?
Here.
47.
But let the friend submits one judgment of Honorable Supreme Court that Abhisar Builders
the series of judgment of this court?
Yes, Lordship, that is based on that Avisar judgment. I was the counsel for the department in that case.
What
But here I want to place assessment order for consideration of the lawsuit.
assessment order?
Yes, whether incoming materials are with those materials which is collected by the authority can be considered the incoming materials or not.
Hmm?
The while passing the assessment order.
Sir, what is the question of law?
Lordship, here the question was framed.
What was that question?
Lordship, the question of law has been
Madam, will ask you, please, wait for your turn.
I'm sorry, Your Lordship.
Lordship, assessment order is it starts from page 8.
Please, read the order.
Lordship.
Question of law.
Yes.
Lordship, they have put it in PG.
Whether on facts and circumstances, honorable tribunal was justified in confirming the assessment here is not abated.
Yes, Lordship.
So see, it is whether on the facts or circumstances, honorable was correct in holding that the assessment here is not abated when no assessment order was
Passed prior to
prior to
passing.
the passing of so and so, so and so. Okay. Now, whatever the assessment order was, the IP,
Appeal.
the commissioner,
Commissioner partly allowed the appeal.
party allowed the appeal.
Not.
Page number 222. Para number 2.
222. For the above assessment here, I note that the appellant had
From the above assessment year,
from the above assessment here, I note that the appellant has filed return of income under section 3172.
where the appellant has duly disclosed the
appellant
income
has
capital
duly
gain and
disclosed the
claim
income capital gain
exemption
and claim of
accordingly
the exemption
admittedly, there was no
There was no
regular assessment was made by the appellant for the assessment year so and so. Also, the time limit for issuance as well as the notice under section so and so act in case above assessment year is already expired on so and so.
Not it.
And such on the date of such in case of appellant that is on so and so. The assessment of the above assessment year was completed assessment and therefore following the ratio of the above judgment discussed above in the absence of any incriminating document or material has already completed, the assessment cannot be disturbed unless the incriminating found and course of so and so. A vivid AO is not referred to any such incriminating error found during the course of the search and so and so. This is clear above addition to the so and so.
Yes, Lord.
Now, the commissioner has decided the appeal solely on the ground that you have failed to show any incriminating material on the basis of this. The assessment can be opened.
This is
the finding of fact.
Yes, Lord.
And this finding of fact has been affirmed by the ITAT also.
Lordship. On the
It's a
basis of
question of law. Now the law is very well settled. Until and unless there is incriminating material, the assessment can't be reopened.
yes, Lordship.
This is what the law is.
This is the law on date.
Yes.
Now, Lordship may has to see whether any incriminating materials is there or not.
So that is a question of fact which we can't go in.
No, Lordship.
That is purely a question of.
No, Lordship, because in paragraph 8 of Avisar judgment, Honorable Supreme Court says,
Yeah.
Lordship, page 17,
With judgment.
page 17 of the compilation given by the enactment law.
Fine.
This is the gist of page 17.
Yes.
Paragraph 8. This is the gist of the judgment law.
Page 17.
Page 17.
Yeah.
For the reasons stated herein below, we are in complete agreement with the view taken by the Delhi High Court in the case of Kabul Chawla and the Gujarat High Court in the case of Samaya Construction, taking view that no addition can be made in respect of completed assessment in absence of any incoming materials. This is the gist of the issue, Lordship. Now, Lordship.
This is now settled that without there being any incriminating material,
Yes,
the closed assessment can't be opened.
Yes, Lordship. Even if it is,
You are admitting it.
if it is admitted or it is completed assessment.
Who to admit?
Yes, Lord. Now, Lordship, I want to place the assessment order.
Sir, assessment order, now it's a finding of fact.
No, Lordship,
Where
if the finding is perverse, then
The
Lordship, you can,
finding is perverse. How it is finding is perverse, sir? Ultimately, it's a finding of fact
no, Lordship,
that there is no increment in material. The assessing officer has found this. Yes, this is the incrementing material. 2 courts below asset gate. This is not incrementing material. That's khatam. Baat khatam, sir.
no, if Lordship, the finding is perverse, then definitely Lordship can consider and
So then,
if
where is
regarded,
the question of law?
then Lordship
Where
can
is the
frame,
question of law?
Lordship can allow us some opportunity to place these materials before a Lordship. That is also permissible under section 260 law.
Yeah,
If Lordship found that during the hearing, if any question is not framed,
yes, certainly.
The-
Okay, what is the perversity?
Lordship, because Lordship may come to page first, paragraph 7, page 12,
Paragraph 7 of what?
assessment order, my memo of appeal law.
Your memo of appeal. Paragraph
First
7.
paragraph 7,
Huh?
paragraph 7, yeah. Page 12.
Page 12, yeah.
During the financial year 13-14, the relevant to the assessment year 14-15, the SEC earned income from salary, capital gain, and other sources. The SEC also received shares of profit from his partnership concerned. The case was examined on basis of documents filed and produced during the assessment proceeding, along with documents available with the office on test check basis as under. Thereafter, Lordship may come to paragraph 7.3 at page 13.
Yeah.
Paragraph 7.2. On examination of the submission of the SEC, it seemed that during the financial year 11-12, the SEC had invested rupees 16,50,000 in penny stock of Messrs. Rupton International Limited. The shares were sold in the financial year 13-14, resulting into long-term capital gain of 4,23,23,173. The amount of rupees 4,23 and other is claimed exempt under section 1030 of the Act. Then paragraph 7.3. However, after repeated requisition, the SEC could not furnish copy of the demat account, counter note, bank statement extra showing the transaction of the investment. Then Lordship next page 14. Modus operandi adopted in case of bogus entry, bogus LTDC. Paragraph 9. When a penny stock, the penny stock are those that trade at a very low price, have very low market capitalization, are mostly liquidate and are usually listed on a smaller exchange. These stocks are very speculative in nature and are considered highly risky because of lack of liquidity, similar number of shareholders, etc. The name of the penny stock is derived from stock list below 5 penny in certain countries. Before proceeding into the case, one has to look into the general modus operandi adopted by the SEC, who have indulged in converting their
So you mean to say that this is what the incriminating material?
Yes, Lordship.
What the commissioner has said?
Commissioner says that these are the not incriminating material.
Where is that?
Lordship, thank you. Page 208, Lordship. Last paragraph.
208.
Lordship.
Yeah.
Last paragraph.
Yeah.
I note that there is absolutely no corroborative evidence found in the courts of search by search team or materials evidence brought on record by the AO, learned AO, in order to give a credence to the statement recorded during search. Hence, I hold that no addition could be made merely by placing reliance on statement recorded during such and also without referring to any incriminating documents or materials. While I have already elucidated the law herein above, I derive the further legal strength from the ratio laid down in judicial pronouncements, where under similar circumstances, the addition made on account of LTGC from the purported penny shares was declared for the want of any incriminating materials or document. And the judgment of both the authorities was based on Kabul Chawla's judgment.
Kabul Chawla affirmed by the
Yes.
Supreme Court.
But Lordship, Supreme Court says that assessment cannot be made on the basis of if there is no incriminating materials. So my submission before Lordship, whether these materials collected by the SEC while passing the assessment order.
Page number 223. While admitting rounds of my decisions were rendered solely on the basis of the fact and observation stated by the impugned assessment order, submission of the ratio of judgment relied upon so is evident my adjudication is purely legal in nature in this case, since the appellant has not furnished the copies of the demat contract account as awarded in the impugned order, these evidences filed before me has not been considered as those are additional evidence which has not been filed without any petition. My above decision is based on the fact that the assessment assessing officer has not referred to any incriminating material or document while making the impugned addition in the hands of the appellants, and thus the impugned addition based on the reference of to any incriminating material in view of the ratio of the judgment of Kabul Chawla were completed could not have been disturbed. This is what the finding of fact.
Finding of the learned.
This is the finding of fact recorded by the
appellate authority.
And the first appellate authority, then the second appellate authority, ITAT.
That is affirmed by the
What they have said, sir?
page 233, Lordship, paragraph 14. Before that, the Kabul Chawla judgment was considered by the Honorable Tribunal. Page 233, paragraph 14. Turning to the facts of the case, it is noted that only on the basis of retracted statement of the IO has made the addition. From the perusal of the assessment order, it is noted that there is no other incriminating material seized during search other than the retracted bold statement of the SEC's father. Addition has been made by AO, which has been retracted with few days, where the SEC's father SSC has alleged coercion duress of obtaining it. Refer page 19 of the paper book. It is noted that other than the statement of his father, which has been obtained under threat or coercion duress, which has been retracted within few days, the AO has made an addition as undisclosed income of SEC's LPGC to the tune of rupees 4 crore 40 lakhs 50,000. However, we find that there, other than the retracted statement, there is no iota of evidence materials to substantiate the impugned addition. The learned CITA has given finding of fact that other than the SEC's father's statement regarding LTGC of SEC, there was no incriminating materials found during search for the assessment year 2014-15. In such scenario, no addition was legally sustainable as held by the Delhi High Court in Kabul Chawla. And in this context, it is noted that similar issue was agreed upon by the case in Mita Gotalia, Supra, Delhi High Court. And it is noted that the several other high courts has also come to similar conclusion, either by following Kabul Chawla or otherwise. This
Do you want in these finding of facts we are supposed to interfere? Sir?
My submission before Lordship that these findings are
in so many words, para number 11 se start hota hai.
Yes, Lord.
The next issue is with regard to so and so, and after considering the material available on record, they said there is no incriminating material. This is purely a question of facts, sir.
No, Lordship, my submission is the finding of both the appellate tribunal as well as the appellate authority as well as the tribunal is perverse to is a perverse finding. Yes. And Lordship, another thing. Lordship, my further submission in both the judgments of Kabul Chawla as well as the Wizards, let's see, what is the definition of incriminating material, which will be considered the incriminating materials, that is not been defined. Only Supreme Court
It
says
has
that.
not been defined. The Supreme Court has affirmed that judgment. What else?
Yes, Lordship, that is my point, and that's why I have read out the paragraph 8 of that judgment. If there is no incriminating, but on facts, Lordship.
Sir, then again you are coming on facts and you are very well aware that
No, because
we can't go into the question of
no, Lordship, that is I know, Lordship, but the finding as perverts, Lordship. Both the appellate or practice. That no, Lordship may consider and no, otherwise Lordship law is against us. But
admit it.
no, Lordship, I am admitting.
Law is
But
against you, it's okay.
no, Lordship. But
you can't change the law.
But assessment order, the materials on which the addition was made, that is something different because he was given opportunity. He didn't submit his demat account and other materials.
Mr. Kayal, if the law is against you, please admit, okay, sir, it is against me. That's all.
No, Lordship, but the facts had to be, Lordship, has to be placed before a Lordship.
Sir, there is nothing, sir. A question of fact, you are aware. We can't go into the question of facts.
No, Lordship, if the finding is perverse, then definitely your Lordship can
Yeah,
consider.
but don't find any findings.
No, that is up to your
Order
Lordship.
is there.
Obliged, Your Lordship.
Pass over meter 37.
Which from the side? Private. Private response. What up?
On the last occasion, Lordship, with the
Joint verification, some joint verification report was.
Lordship. Lordship has stated that whether the DO was present in the meeting or not in that case because they had not challenged the minutes of the meeting.
The state was directed to.
This is, I was directed to produce the original copy of the joint verification report, Lordship. But my instruction is that, Lordship, and that should not be find out. So in this respect, I have filed one affidavit also.
That should not be.
That should not be find out, Lordship, because that not be specific.
Not be find out.
Yes.
So if joint verification report is not
Because
there.
as such, Lordship, we have in fact, that I have annexed 2 letters, Lordship, shows that, Lordship, that was under the.
Chalo, we'll hear it after 2 weeks.
There are certified copies of Lordship is available in the affidavit.
Certified copies are available.
Lordship, they have submitted.
And very original.
They have annexed it.
Not present.